Let's try that again. I've had to resolve that. So sorry about that. I'm Kamari Clark, a professor here at the center, and I'm moderating the session for today. We have LSQ interpretation, accessibility from English to LSQ. So we welcome the interpreters also. I'd like to begin with a land acknowledgement in order to express our gratitude to those who reside here and to honor the Indigenous people who have lived and worked on this land historically and presently. We wish to acknowledge this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron, Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people across Turtle Island. We are grateful to have the opportunity to work on this land. While we seek to understand our history and place here that has brought us to this land, this is an expression of gratitude. It's a way of honoring the Indigenous people of this land who have been living and working on the land for time immemorial. We say thank you. I have the pleasure of introducing the lecture and our guest, and I'll, of course, be moderating. The lecture takes on a range of key developments since the onset of COVID-19 and the requirements for physical distancing. And as a result, several Canadian courts have embraced digital technologies to conduct remote hearings of cases. And this, of course, has included the Supreme Court of Canada. What we've seen is that the way digital technologies in criminal courts have led some to advocate for their expanded use after COVID-19. And while on one hand, using digital technologies in our criminal courts has proven beneficial, on the other hand, it also has had cultural and political and racial implications for how we understand the role of the judge, the accused persons, as well as the accused person's perception of this role. It raises a whole set of questions about pervasive social inequality. And one of the key questions that will be at the core of our discussion today and of the presentation really has to do with the extent to which video conferencing technology is actually changing the social landscape and the implications for social inequality in our world. And we're interested in the implications for racialized peoples and peoples in general, and what these technologies mean on this changing landscape. But before we go to what is going to be really an exciting conversation, both presentation and conversation with our moderators or our commentators, let me just go over a couple of logistics related to the event for today. The event will be live streamed via YouTube. It is being live streamed now as we speak. The format is one where the presenter will introduce his paper. He'll have about 50 minutes to do that. And then we'll have two responders who will comment, both affiliated, one a graduate student, a PhD student in our program, and another a faculty member who is teaching in the program. And so they'll have about 30 minutes, 15 each, to comment on the paper. And then from there, we'll give Professor Ayadele a chance to respond. And then we'll have an additional half an hour to 45 minutes for questions and comments. Questions and comments will be taken in the chat. So feel free to put them in the chat as we're going along, of course, on the YouTube chat. So as we go along or toward the end, that's fine as well. And when we get to that point, I'll be keeping track of the questions, reading out the questions, and asking our speaker as well as our discussants to engage in some of the questions in the chat. And so, so that's the plan for today. We have about 2 hours, so my job will be to moderate and to try to move us along. And it really is a pleasure to engage in a topic that's so significant and has serious consequences, both in the ways that COVID-19 is being managed, this pandemic is being managed in our own backyards, but also what the implications are for future adjudicatory processes in our country. And so next I'll introduce our guest. It's really a pleasure to introduce Dr. Ayodele Akinroye, who is currently a postdoctoral fellow at the Center for Criminology and Socio-Legal Studies at the University of Toronto. His ongoing research closely interrogates the use of video conferencing technology in Canadian criminal courts and how its usage clashes with the charter rights of accused persons. In this regard, he's interested in challenging the cultural assumptions about how the role of the judge is performed and the image of what the judge ought to be. Dr. Akinroye is also a tribunal member. He's an immigration judge and with the Immigration Division of the Immigration and Refugee Board of Canada through the Government of Canada, where he makes decisions in admissibility hearings and detention reviews for foreign nationals or permanent residents believed to be inadmissible or removable from Canada under the law or detained by the Canadian Border Services Agency. And so he really does come with a wealth of experience, especially of late in what he draws from his research. And to date, much of the work that he's presented is a work in progress that is also being supplemented by qualitative and quantitative work. He received his Bachelor of Laws degree from Obafemi Awolowo University in Nigeria in 2007, a Master's of Law degree in International Law from the University of Manitoba, and then a PhD most recently in International Criminal Law from McGill University in Montreal, and that was in 2018. Now, he has extensive, of course, law experience in multiple fields. He has acted as the Deputy Chief Commissioner of the Residential Tenancies Commission with the government of Manitoba. And he has been called to the court, to the bar in Ontario, and has practiced as a criminal barrister before different courts in Canada. He also has it's worth saying this because the paper is certainly concerned with some of these juridical questions about law and the judge and lawmaking. And so it's not just the domestic, but in the international realm, Dr. Akinroye has years of experience working in international criminal law. And it's actually in that context where I came to know him and his work when he was working as a legal professional for the International Criminal Court in The Hague. And also he has worked with ECOWAS Commission in Abuja, Nigeria. So I could go on and on with his bio as a young and up and coming scholar. He has tremendous work experience and has done tremendous work, not only in Nigeria and in the African context, but in relation to international criminal law. And so it really is a pleasure having him at the center. He's the author of book chapters, articles, and he really is a wonderful interlocutor. So it's a pleasure to have him with us today. His talk is entitled Wheels of Change, Critical Considerations, Visual and Digital Technology in Canadian Criminal Courts. So please join us in welcoming our guest today, Dr. Ayodele.
Thank you, Professor Clark, for the introduction. I'll be sharing my screen now, so please give me a minute to share my screen. Please, can you confirm you can see my screen? Okay.
Yes, we can see it fine. Thank you, Ayodele.
Okay, thank you. So, good afternoon, everyone, and thank you for attending my talk today. I want to start by thanking Professor Kamari Clark for giving me the platform to conduct my research at the center and for also acting as a moderator today. I also want to appreciate Professor Audrey McLean and all the good people at the Center for Criminology and Social Legal Studies for giving me the resources to conduct my research on digital justice in Canadian criminal court. Before I go into my presentation today, I also want to thank Ms. Wumi Asunbiarodada and Ms. Anne-Marie Murphy for accepting to be the discussant of my paper this afternoon. Let me start by sharing a work story. In my other capacity, as mentioned by Professor Clark, I've immensely enjoyed my other capacity as a tribunal member. I've immensely enjoyed the ease of using technology to conduct remote hearing. But it wasn't until the person who was incarcerated in a provincial jail and was appearing before me via teleconference referred to me as a bro, constantly referred to me throughout the entire administrative proceeding as bro, bra, was variation that I had an awakening that while using technologies to conduct hearing is beneficial, it could actually undermine the fundamental tenets of our judicial system, grossly distort the image of a judge, and be prejudicial to the interest of the person appearing before a court. My objective in my presentation today is to illuminate or to explore how the adoption of video conferencing technologies such as Zoom, WebEx, and MS Teams, and other electronic platforms in Canadian criminal courts are challenging the legitimacy and authority of the judge and reshaping and renegotiating the cultural image of a judge. Just like Professor Kamari Clark has said, this presentation is a work in progress and part of my larger postdoctoral study at the University of Toronto. It's far from being concluded, so I look forward to the discussion. Just to issue a caveat here, this represents my own personal view, and it doesn't represent the view of the Government of Canada or the Immigration and Refugee Board of Canada. So let's go back. Since March 2020, when COVID-19 was declared a pandemic worldwide, resulting in the restriction of on-travel and in-person gathering, most courts in Canada canceled all previously scheduled trials. This led to an exponential increase in the already sizable backlog of cases waiting to be adjudicated, therefore affecting the mental health of people in detention due to the increased use of medical isolation, quarantine, and solitary confinement as measures to contain the spread of the virus in prisons, and eventually eroding victims' confidence in the ability of the criminal justice system to deliver a fair verdict. Stakeholders such as criminal defense lawyers critique the Canadian criminal justice system as being outdated, archaic, and heavily reliant on close physical contact, paper documents, and personal appearances, all which are outdated approaches that are failed to adopt new technologies at the same pace as other Canadian institutions. This led to a strong push for Canadian courts to adopt video conferencing technology to deliver meaningful justice to the accused, victims, witnesses, and people such as First Nation constituencies in remote locations. So what does that lead to? It leads to an increasing use of video conferencing technological capabilities in the criminal justice system in case preparation, plea negotiation, and potentially for trial. And this new move also has policy implication. For instance, the Attorney General of the Ontario province reallocated the funds earmarked to build a new courthouse in the Alton region to technology, arguing that it is high time to modernize the justice sector in Ontario and investing significantly in technology to take our courts online is the way to go. Canada is not alone in embracing video technology and investing significantly in technology. Courts around the world are investing in technology solutions and are replacing face-to-face hearing with audio or video hearings using technology platforms such as Zoom, MS Teams, and Skype. So here's the issue. As courts in Canada undergo these rapid transformations, the physical courtroom is becoming a contested space in which questions abound about the importance of the administration of justice, reflecting the changing needs of society. So through this narrative, there's an assumption that the integration of video conferencing technology into the courtroom will reduce cost and increase access to justice without putting accused person at a disadvantage or breaching their procedural right. Why this could be true to an extent, the alternative narrative is that video conferencing technology disrupt and call into question long-standing assumption about the need for a physical location as a central domain for the authorial execution of justice. So through space, they allowed all of the courtroom. The declaration through speech asks that all should rise for the judge to be seated. The actual physicality of hierarchy is disturbed. So both sets of narrative highlight the image of a judge, but one demands contemporary solution to contemporary problem, and the other insists on the necessity or insists of the necessity of visualized space to be central to the authorial power of the judge. So when I reflect on this dynamics, what we see at the heart of the contestation is the contemporary nature of judgecraft. And in the later portion of my presentation today, I'm going to talk about the impact on judgecraft. So through the identification of judgecraft as a process for the skillful management of legal decisions, not only through the use of various technological tools to interpret and apply the law, but also the presumed command of the authority of the court through the perceived legitimacy of its office. So I argue that it is the production of authority and power along the technocratic tools to rationalize legal decisions that are at the heart of this contestation. So in so doing, what we see is that there's a need to closely interrogate how the legitimacy of the judge is challenged and the social control wielded by judges is lost in the process. Some might say these are academic or tangential, but I say no, they are not. The stakes in the move to virtual hearing are very high, particularly in the criminal justice system, where Canadian courts must zealously protect the charter rights of accused persons, including the right to speedy trial, confrontation of witnesses, and an open court. So now I'm going to turn my attention to the role of architecture in our court system. So since antiquity, authoritative justice has been performed at a proclaimed place known to the entire community. While the proclaimed place is not fixed and has evolved over time from outside, like the stones on which the judges sat, as depicted in the Achilles shield in the Iliad, or the trees under which the South African community tribunal were traditionally conveyed, to the present day modern imposing courtroom architecture primarily dedicated to the adjudication of dispute. Courthouses are designed to symbolize certain ideals and community values in the public sphere and define the sort of acceptable behaviors and experiences that participants will experience once they get inside. It also signals that the place of the trial is in some ways special and out of the everyday. And this fosters the basic political legitimacy of our courts everywhere, and the social controls it exercises over the participant in the justice system as well as in the general public. Over time, the physical place of justice has been synonymous with the location of the judge, and physical courtrooms are widely believed to imbue judgecraft with a mystique of authenticity and legitimacy. So the contemporary, carefully conceived and curated iconography of the physical courthouse conveys to the public and all the participants who attend these hollow halls of justice of the society's ideals of how justice is to be dispensed in the maintenance of law and order and the promotion of shared community values. So according to per other. He said, and I will quote, open quote, architecture marks off and signify that authority to judge, which can only be found inside a court of law and nowhere else. It assigns legal discourse to a proper place. For instance, let's bring it down to Canada. In constructing the Supreme Court of Canada building in Ottawa, the goal was clearly communicated as follows, open quote, for the highest court in a democracy, the architect had to convey an impression of unquestionable authority through the use of vast proportion and a severe decor and the transparency of action symbolized by natural light. End of quote. By its very nature, attending a physical courthouse conjures an understanding of being part of a specially and culturally acknowledged type of activity which requires appropriate behaviors. Nothing represents the society's conception of justice being not only done, but seen to be done than the spectacle of trial by juries, peers in our criminal court. The carefully spatial layout of the courtroom with the royal coat of arms behind the raised dais where the judge sits, representing the full majesty of the law. The dock where accused persons are seated while waiting for the verdict of their peers, and the 12th juror, who we can call wise men, seated in their jury box, lawyers fully robed in their legal regalia, witnesses called and sworn to tell the truth, the whole truth, but nothing but the truth, and court proceedings watched by the public and reported by the press or court watchers all contribute to distinguish the office of the judge, promote the legitimacy and the authority of the judge, who is charged with the role of making life-changing pronouncements on behalf of the community. So therefore, a judge's decisions require particular social, temporal, and spatial framing to have effect, and the need to establish a special judicial space, a civil space, through which these pronouncements are made is therefore important to help legitimate the adjudication, rather. So I'll turn my attention now briefly to how the Supreme Court of Canada has interpreted it in recent times. Here we have an image of the first ever fully virtual hearing of the Supreme Court of Canada, which was conducted on June 9, 2020 through Zoom and live stream on the court website. In his opening speech, the Chief Justice of Canada said, open quote, just remember that we are here for your arguments, not the angle of your camera or your facility with the mute button. We will get through this hearing just as we get through this pandemic, end of quote.
Excuse me, Ayo, I'm sorry about this. You may not realize, but we're having an issue with the translation, and there's a suggestion that perhaps we ask you to turn off your camera, and that might allow us to see the translator, the sign translator. And if you could just turn it off while we're watching the PowerPoint, that might help so that others who need the translation can actually see the sign interpreter. So if you don't mind turning off your camera, we'll still hear you and we'll see your PowerPoint. And then as soon as you're ready to release the PowerPoint, you put back on your camera. Is that okay with you?
That works for me. I will stop my presentation.
Thank you. Sorry for the interruption. So sorry.
No problem. No problem.
Okay, so let's see if this works then, if we're able to see the interpreter. Maybe, I know if you could start speaking. Yeah, turn off the camera. And if you start speaking, we can see if the interpretation can happen alongside your presentation. Thank you.
Does this work now? Is it okay now to proceed?
Why don't you continue, and we'll see if we can
Okay.
working, and I'll let you know. Thank you. Sorry about that again.
Okay. Thanks. So the Chief Justice of Canada said, and I open quote again so that I can go back to that quote. He said, just remember that we're here for your argument, not the angle of your camera or your facility with the mute button. We will get through this hearing just as we get through this pandemic. End of quote. Of course, there was an hiccup. One of the counsel appearing had issues with the sound and video, and the Supreme Court had to take a break to resolve the technical glitch. But look at it, we are at June 9, 2020. Let's look at what happened at the Supreme Court of Canada just 3 months after this first virtual hearing. Here we are. On September 22nd, 2020, the Supreme Court of Canada conducted the first physically distanced hearing. In the notice to the public, the Supreme Court stated that measures were put in place in the courtroom to meet physical distancing requirements, and hearings will also take place by real video conference for counsel who cannot attend the hearing in Ottawa. So what changed? Why did the Supreme Court of Canada move from a fully virtual hearing to an hybrid format? Even in this hybrid format, you can see some courtroom rituals being practiced. I will now turn my attention to the role and place of rituals in court. Centrally located in the legitimation of the lawmaking role of the judge is the role of rituals in legitimatizing their decisions and judgment. Rituals such as stare decisis doctrine, doctrinal formulas, and rules of procedure were considered to be nothing but magic solving words, word rituals, or legal myths, concealing the influence of personal preferences and ideology on decision making. For instance, the all familiar, long-standing court rituals of the court clerk ushering in the judge by yelling, "Oye, oye, oye," anyone having business before the Queen's Justice of the Superior Court of Justice draw near, and you shall be heard, long live the Queen. Court participants standing up when the judge enters and bowing to the court on departure, all have performative effect of casting the judge as an independent authority and the custodian of our community values. It also set the stage for the acceptable civil modes of address, as well as respectful and polite behavior expected of all the courtroom participants. Thomas Arnold refers to judicial rituals as magic realism, which posits that symbolic aspects of judicial practices are useful and have practical relevance, and the character of judicial system would thus be profoundly altered if we were to do without this folklore and spiritualism. Another author, Allen, theorized judicial rituals as a ritual magic mode of adjudication that is not necessarily contrary to legal reasoning. The primary function of adjudication is not to explain the decision, but to transform the social fabric. Law constitutes and transforms social meanings by helping to create and recreate the social situation at issue in adjudication. Ritual magic is a long recognized mechanism of such transformations. So, in law, as in ritual magic, transforming the meaning of a set of social circumstances can happen through common formal and performative techniques that may look like mere distractions or ways to disguise what is really going on. In fact, some function of law in our society may depend on this technique, not because they confer logical, rational correctness or predictability, but because they may contribute to judicial impartiality and because they may provide a mechanism through which official legal decisions on some of the affective power of lived experiences and so generate the personal and collective commitment that leads to social transformation. So, in particular, rituals reaffirm the power of judicial decisions by replicating and reigniting conflict in a symbolic fashion during trial. They enhance the judge and jury's impartiality, and they symbolically replicate the triumph of social life over death and mobility. Let's consider another author on his view on judicial rituals. In an essay on judicial rituals and the function of judging, Antoine Garapon, a French magistrate and author, argues that judicial rituals are a condition sine qua non for law to exist in practice. So he identified three functions of judicial rituals at trial. Number one, breaking out of ordinary experience. Number two, purifying the experience of crimes that are reenacted during trial. And number three, representing and commemorating legitimate authority. So rituals put tensions at ease and diffuse violence by transforming real fights into symbolic struggle. Garapon argues that the actual person of the judge does not count as much as is or a symbolic figure. The judge is a fictitious entity, just as the legislator is. He or she carries out an act of speech, which gains, by virtue of the surrounding rituals, a performative function. In other words, with the ritual and robe, a judge renders justice whenever he or she utters the law. So Garapon argues against the desacralization of judicial rituals. For him, he said, without rituals, it becomes difficult to know who renders an authoritative decision. Without rituals, the decision of a judge is no longer presented as being the right decision. This could result in the reasons for the decision being questioned, and indeed, even in the disappearance of a need to give reasons. One of the central arguments in the use of video conference technology is that the criminal justice system in Canada needs to undergo structural reforms in order to make the adjudication of trial more efficient. And to achieve this objective, there's a need to reduce or completely discard judicial ritual, which can be time-consuming and expensive. But the reality is that the entire judicial system is built around rituals in order to provide it with the self-sustaining logic and legitimacy. And a de-ritualized criminal adjudication may result in the loss of legitimacy for our judges. It is therefore necessary to consider that there may be other ways of creating judicial rituals in order to produce legitimate decision. For instance, maybe for example, greater participation by the parties, including an opportunity to define the appropriate rituals, could not only ensure that judicial rituals remain at the forefront of any decision rendered, but also that the dispute resolution process is more efficient. I will now turn my attention to the image of a judge. With the increasing adoption of video conferencing technologies, particularly the context of COVID-19, the unique image and the role of the judge is being renegotiated, dispersed, and their relationship with court participants and the public has dramatically shifted, as judges are now not confined to the same courthouse or courtroom as other participants. Court proceedings are now a specially disputed event, extending the boundary of the court to other buildings such as library, lawyers' offices, police stations, and now the private homes of accused persons. The OC migration to remote hearing with the use of video conferencing technologies such as Zoom, WebEx, MS Teams, and other virtual platforms disrupt the way judges usually appear to court participants, how they are imagined culturally, and the mistake and aura that judges have enjoyed historically is likely stripped away. Remote hearing tends to remove some of the perceptual cues which normally trigger the performance of long-standing symbolic and performative rituals as previously discussed. And different empirical studies conducted in Australia, the UK, and the US shows that attending courts from remote locations significantly alters the experience of justice for all involved. The lack of formality and highly dispersed distributed court environment that remote hearing portrays has significant implications on the experiences and outcomes for judges, accused persons, victims, and indeed the Canadian public. And this requires further interrogation, and I will attempt to do so in the next couple of slides. The public-facing aspect of the role of a judge helps to create and sustain their cultural image. The judge embodies the authority of the court as the final arbiter of disputes, with the integral role of managing the court and other courtroom participants. Rosen and Wallace argued in the seminal book work that any dissonance between the image of the judge and the nature of their role potentially distracts from their effectiveness, because courts, unlike other branches of government, rely on public acceptance of their legitimacy. So what happened in a typical court, criminal court? In a typical criminal court with an adversarial model, the judge is tasked with conducting preliminary hearings, taking guilty pleas, presiding over trials, sentencing accused persons, delivering rulings or judgments, and hearing appeals with the integral responsibility of controlling and monitoring the proceedings to comply with the applicable rules of evidence and procedure, and ensuring that all the courtroom participants behave appropriately. The judge decides what evidence is admissible and how it is given, such as whether in the form of in-court testimony or by video link. The judge may also direct questions to a witness, although this has to be carefully done in an adversarial model. A judge with a fact-finding mission will listen to evidence presented throughout the trial and draw conclusions from them to make a determinative decision or judgment. This might include forming opinions as to the credibility and reliability of a witness to determine if the witness is telling the truth or not. In the context of a jury trial, the judge sums up the facts for the jury and directs them as to the applicable law in reaching their verdict. This fact-finding work of a judge usually involves a series of cerebral operations, some simple, others complex, some sequential, others simultaneous. It can be frustrating and excruciatingly difficult. So what happened to the image of a judge with the move to remote hearing via video conferencing technology? Judges are now in an informational environment that's more intensive, more extensive, and less controllable than it was in the past, with far-reaching consequences on participants. For instance, it's argued in Weberian terms that judges' performance or enactment of their authority in the courtroom reinforces law's claim to legitimacy. And this requires an assurance of procedural fairness, which in turn requires a degree of engagement between the judge and other courtroom participants. Remote hearing disrupts this in a number of ways, including that the technology or connection does not always function properly. The video takes away the judge's ability to assess non-verbal cues, and video conferencing technology can actually filter out frequencies associated with human emotion, which are very critical in assessing credibility and reliability. Well, it also has impact in the sentencing, as it could depersonalize the entire process and drastically minimize effective judicial engagement, which is one of the hallmarks of therapeutical and problem-solving aspect of judgecraft. And this is frequently deployed in our GLADU, mental health, and drug treatment courts. So during sentencing, if we focus on sentencing for now, judges employ a range of communication strategies to achieve legitimacy, such as directing their gaze and speech directly to the accused person to create a more engaged and personal encounter. This communication strategy employed by judges are usually deployed to address offending behaviors in drug addiction, homelessness, and mental health cases. In fact, Liu and Mark and Wallace in their work argue that judges require a more relationship approach to judicial work, and judges make greater use of their personal and interactional skills to secure more effective sentencing outcome. That becomes a little bit problematic in the context of video conferencing technology. So what do we have? What is left in any criminal court proceeding? As you can see from the image I've just projected, is a computer interface showing the head and shoulder shot of the judge, the crown attorney, the defense counsel, and the member of the jury. And the accused persons are shown with no meaningful engagement between the participants. Due to the lack of this bodily co-presence and full sensory engagement with remote hearings, most participants, including judges, feel depersonalized, as I've said before, and see the experience as a less human experience and eventually, or even less humane. In fact, an Australian judge emphasized the importance for them that all litigants come together in one place as a reminder of the human condition, and that the difficult decisions being made in court are not undertaken lightly or flippantly. The public needs to see that. The judge believed that those sentiments are very difficult to convey to a person appearing remotely. And then it also has impact on another aspect, which is aspect of the typical courtroom atmosphere, which is very important in conveying solemnity and framing the judge as legitimate and authoritative. And the spatial distances between all the court participants evaporate in the context of a virtual hearing. I will now turn my attention to, in the next slide, or a few more slides, to what happens when we lose the structure of the court and the atmosphere. The notion of court atmosphere is also called affective atmospheres, which means the assembly of affects that both the material and human give cause to and reproduce. It's used to explore collective affective qualities that are perceivable as they emerge between bodies and their environment. These affective atmospheres are usually materially crafted in physical courtrooms and engineered through the material arrangement of the courtroom. Philopoulos Mahalopoulos argued in his book that there can neither be law nor justice that are not articulated through and in space. What this argument highlights is that the court architectural designs provide the spatial arrangement for the engineering and crafting of the affective atmospheres, which communicates community values and the importance of the maintenance of the law and order in the Canadian society. The interior arrangements and the aesthetical layout of the courtrooms create resonance between the physical bodies, provide judges control over the situations, and at the same time project the visual and material representations of law in operation. The physical courtroom arrangement also cue particular type of behaviors to encourage participants to conform to the norms of the legal ritual occurring. This cues has been described as the coercive power of the courtroom and the judge, as deviant behaviors by participants could lead to a charge of being held in contempt of court. What happens now in the context of remote hearing? Participants who are participating in court proceedings via video conference technology lose the affective atmospheres of solemnity, respect, deference, and the formality of a courtroom. And in turn, the judge loses the authority and power of discipline hearing participants far from the physical reach of the judge. In fact, some judges reported that some litigants were unruly while remotely participating in court proceedings, emboldened by the fact that they are not in the same room as the judge and are on their own territory. As such, they don't have to be told what to do or how to act in their own environment. Remote hearing reconfigures the encounters in the courtrooms and remodify the relation between the law and the people subject to it. While embracing the virtual hearing environment could be seen as an easy solution to making the court atmosphere less daunting and easily accessible to vulnerable people, minors, and first-time users of the court system, has been frequently articulated by different people from different constituencies, it might actually have unintended consequences. For instance, a study conducted in Australia revealed that the interviews indicated that the video link fundamentally disturbed courtroom interactions and its rituals, with these interviewees less comfortable with the experience overall. Another Australian study on remote hearing also suggests that the use of video link alters the representation of the judge as the embodiment of law, weakening symbolic and cultural dimensions and undermining the gravity and decorum of court proceedings. Most participants also indicated that they missed the display of justice in practice, the respectful and solemn atmospheres and behavioral cue conveyed by the impressive architectural designs of our courts were lost. While the use of video conference technology, it does opens up the traditional courtroom to multiple and simultaneous interactive sites of adjudication and provide broader access to the public. Yet studies have shown that participants in court proceedings through the video conference technology or via a video link most often find themselves in spaces that could be characterized as bland, ordinary, and mundane. Studies found that accused persons who participated in remote hearing found the judicial process as less legitimate, with them less likely to have legal representation, as they do not take the entire process very seriously and therefore have negative impact on outcome for them. The image you're looking at is actually the image of an accused person in the middle of his extradition hearing, being to be extradited from the United Kingdom to the United States. As you can see, he's just frustrated, doesn't even understand what is going on. He's not even interested. A September 2020 report issued by the Law Society of England and Wales raised significant concerns that a mere 16% of solicitors polled reported that vulnerable clients were able to effectively participate in remote hearing. Just 16% of solicitors who had vulnerable clients. They said only 15, just few vulnerable clients were able to effectively participate in remote hearing. In situations where client had no particular marker of vulnerability, only 45% of solicitors reported that those clients were able to participate effectively. The report also indicated that people who do not communicate regularly via phone or video conferencing find the experience very disconcerting and struggle to follow what is in an already unfamiliar legal process and find it difficult to adequately present their case. The report also indicated that body language and signs of distress were not picked up on as easily like when you're in the physical courtroom. In the next slide, a couple of slides, I'm going to turn my attention to the impact on open court principle and judgecraft. One of the significant impacts of remote hearing is redefining the concept of open justice, which plays a critical role in the court, carrying out important adjudication functions involving the exercise of judicial power and giving legitimacy to our judges. Throughout the years, in the pursuit of open justice, evidentiary hearings and trials are generally live events conducted in a dedicated physical space accessible to the members of the public, the press, and court watchers, with the goal of ensuring just procedures and outcomes for all the participants. The liveness, the momentousness, and the visibility of hearings and trials are what metaphorically makes the courtroom a stage and the trial as theater, which is always notionally part of the spectacle of performance that our judges engage in every day. It also serves as a reminder that judicial proceedings are not merely private interchange, but an important function performed on behalf of the community, in which community-wide problems are addressed and norms are articulated. For Thurman Arnold, a public trial, particularly in the context of criminal trial, especially a criminal trial, represents the dignity of the state as the enforcer of law, and at the same time, the dignity of the individual, even though he be an avowed opponent of the state. So, like other common and civil law jurisdictions, the open court principle is a key bedrock of our judicial system. In Canada, as enshrined in the Canadian Charter of Rights and Freedom, and ensures that public confidence in the integrity of the court system and the ideal that the administration of justice is promoted by openness and public and full publicity, rather, please. Even the Supreme Court of Canada has held that the open court principle is a hallmark of democratic society that gains importance from its clear association with free expression protected by Section 2B of the Charter. However, the move to remote hearing raises the important questions. Where is the court located? Whose right is the right to a public trial? And what precisely is the role of the public in securing this right? These Questions are very important, and it is very crucial for the community to know where to go to see justice being dispensed. The need for a court to be easily located by the public, for them to readily view proceedings, which are the hallmarks of the open court principles. A major criticism of remote hearing via video conferencing technology is that it restricts public access to judicial proceeding and breaches the open court principle. An opposing argument is that court proceedings can be broadcasted to the public through technology platforms such as YouTube, and that it will satisfy the open court principle. It further argued that the public gallery in our courtrooms is typically not utilized by spectators on a daily basis. So the impact of moving judicial proceedings online and broadcasting them through YouTube is not detrimental to the open court principle. In essence, the argument is the virtual presence outweighs its urban presence. To address this issue of open court principle in light of COVID-19, I'll focus just on one court, the Ontario Court of Justice, issued a notice regarding public and media access to judicial proceedings. The court acknowledged that there may be restriction to the public participating in judicial proceedings due to technical limitations, legislation, publication ban, or court order. But in any other cases, members of the public and the media who are interested in observing proceedings can email the respective courthouses to obtain access details. The notice did not, and I read it carefully, did not indicate that judicial proceedings will be live streamed as it is currently structured. Obtaining access details is not user-friendly and directly undercut the well-entrenched idea that one can just stroll into a courtroom or a courthouse without having to make an appointment or being turned away at the door by the security. So this throws up a critical question. Is it acceptable for some participant to access the court proceeding remotely? And why not the general public? Those questions are some of the questions we'll engage in during the Q&A. I will now turn my attention to the other aspect of judgecraft. Exercising adequate judgecraft with the use of video conference technology is very important in achieving temporal goals and can further create space for a more engaged and legitimate decision-making process in Canadian criminal courts. So what is judgecraft? Judgecraft is a practical craft and is firmly bounded with the legitimacy of judicial authority. So based on the relational concept of procedural justice, the legitimacy of judicial decision is bolstered in part to the extent to which courtroom participants perceive, it's very important, perceive that they are being treated fairly by the judges they encounter. What this translates is, it means that there's a need for more active engagement by judges in our criminal court. But this could at the same time runs contrary to the adversarial norms, which requires a formally passive judicial role with more active roles for other participants. So what are my findings on the personal observation of court proceeding in some Ontario criminal courts? I did find that video hearings require additional judgecraft to effectively manage the hearing and maintain the authority for our judges. For instance, it was difficult, for an example, it was difficult for our judges to manage participant reaction, and participants were more likely or are more likely to talk over one another due to the lack of physical cues around turn taking. I also found out it requires extra time to use formal turn-taking cues, which might otherwise be picked up visually or intuitively in a physical hearing. Also, I found out that participants, including vulnerable persons, are more likely to go off on a tangent, and it was more difficult to get participants on track via video hearing, unlike when they are in the same physical space. Another concern I found out includes the ability of a judge to determine if the parties are following the proceeding through video hearing. So, due to the increasing caseload in our criminal court and the need to meet the presumptive ceilings for the completion of trials as established by the Supreme Court of Canada in Al versus Jordan, there could be heightened, or there is heightened time pressures in our criminal court to quickly complete cases, and this creates additional problems. With actively managing multiple tasks and the unpredictability of the criminal list for our judges. With the move to video hearing, these problems are even more acute and challenges the ability of our judges to create sufficient time and attention for active engagement required by procedural fairness values which underpin legitimate judicial authority. In general, I found that video hearings are more draining, stressful, and tiring for judges, especially those in the mental health and drug addiction courts. A significant amount of time is spent on establishing sufficient technical connections for all of the participants. In the next few couple of slides, I'm going to talk about what happens when there's a displacement of our community values. One of the crucial issues is if the use of video conferencing technology for the purposes of remote hearing adequately convey to court participants a sense that the judge is dispensing justice on behalf of the community and in accordance with its values. The tangibility of that community through proximity to other community members is visibly absent through remote hearings. For instance, judges in the UK, in the US, and even in Australia, they had mixed feedback about the formality of video hearings, the way the authorities were perceived, and the challenge of maintaining authority and a formal atmosphere without the physical cues of a live customer, as I've discussed before. And also, they felt that they were not dispensing justice on behalf of the community adequately. Most judges, particularly in the UK, felt that it would be useful to have a court seal included in the video hearing to remind participants of the authority of the judges to dispense justice on behalf of the community. This throws up several issues. So let's look at it carefully or closely. If an accused person being sentenced by a judge do not have a sense of being in a courtroom setting, it may also mean that they do not recognize that they are participating in a group performed ritual with a long tradition that is enforcing the community values of the society. In turn, this alters the perception that all participants have of both the outcome and the process. I argue that there's a need for a judge to feel that the values they are enforcing are those of the community they represent and serve, and it reflects the chain legitimatization that authorizes the judges to adjudicate the dispute. When the judge loses the community context of their work, as typified in a traditional courtroom, there is that anxiety and fear that the adjudication and any judgment issued will be perceived as an arbitrary act of violence against the accused person. The fear is that moving the courtroom entirely remote, participants may fail to perceive the court and the judge as legitimate and authoritative, as I said before. This fear is legitimate and should not be discarded. As studies in the UK found, like I've said briefly before, that accused persons who appeared by video saw the process as less legitimate and were less likely to have legal representation. This failure to obtain legal advice and representation may be linked to an accused person's diminished ability to effectively present their case, resulting in worse outcome for them. So it has to be considered closely. So what do we find on the street? I went on Twitter in putting together my thoughts, and I saw what different comments about the impact of remote hearing on the ground. I'm particularly interested in, you can take time to read through the created tweets, but I'm particularly interested in the tweet by Lizzie. She essentially said, not everyone has access to a smartphone or internet. This digital divide, as identified by Lizzie, is more acute with racialized groups, new immigrants, and people experiencing homelessness and or poverty. And it is important in the courtroom design as we are moving towards virtual hearing as we deal with COVID-19. It's very important for all members of our community, including racialized group, to have equal access to media and technology to participate effectively and meaningfully in remote hearing. Failure to do so will perpetuate the existing inequalities in our criminal justice system, where there are two types of justice, one for the rich and largely white, and the other for the others, which include racialized communities and people that are experiencing homelessness and poverty. So it's very important for our court designers to prioritize the participation of people, racialized people, new immigrants, and vulnerable people who have been traditionally excluded from and attacked by media and technology in framing the discourse around the use of video conferencing technology in our criminal defense, in our criminal justice system. During the course of the Q&A, I'm going to explain more, expatiate more on this impact of this racial discourse and the use of digital justice technologies in our criminal court. Final thought. I've demonstrated that judicial architecture and rituals play an important role in legitimatizing the Canadian criminal justice system. And as there's a continued scale up in the use of the video conferencing technologies to conduct remote hearings in our criminal courts, it's very important not to ask the question, what do we have to gain or lose from adopting video conference technology? Rather, what we should be asking ourselves is the important question of how best do we use video conferencing technology in a way that corresponds to our fundamental legal principles, project the right image of our judges, and promote their legitimacy as the custodians of our community values. Over the years, sociologists have suggested that the perception of legitimacy and due process are imparted by the space of law and people's encounter with it. Therefore, it is safe to argue that the sources of the increasingly use of video conference technology in a criminal court is contingent on the existing symbolic function of the physical courthouse and the rituals not lost, but being identified and being reimagined. I'll now turn this presentation over to the discussant, and I look forward to a rich discussion of some of the ideas that I've articulated in this discussion. Thank you, everyone.
Thank you, Dr. Akinroye. And yes, okay, great. You've unshared so I will also put my video on. The PowerPoint is no longer there, so thank you. So let me just move things along then. We have two discussants today. and so much to talk about. I mean, in your presentation, there's certainly a tension between, on one hand, questions of legitimacy and authority of the judge, on the other hand, and the extent to which space and the place of the courthouse is essential to that. On the other hand, um, people's relationship to this new modality and the implications for this sense of authority. And there are larger questions about the extent to which, even prior to COVID-19, to what extent there exists authority, or whether or not um, it's it's always deserved in all cases. Uh, and so clearly you're doing a deconstruction of ritual and pushing us to think about judgecraft as a particular kind of production of authority and its implications in this new situation. But there I think, a lot of unresolved and fascinating, as well as um, probably controversial issues at play here, and your experience as certainly in the role of a judge, as well as in your capacity as a lawyer, um, certainly sheds light on some of your initial thoughts, as well as the data you've collected thus far. So thank you for that. And I think it's really time for us now to roll up our sleeves and take on some of the very forceful arguments, but I suspect that we'll also have some disagreements on that. So we welcome that as well. Our first discussant is Anne-Marie Morfu, and I have the pleasure of introducing her. She's a principal lawyer at Morfu Symes Barristers. She received her law degree from the University of Ottawa, where she graduated magna cum laude with her JD in 2011. And she also received her BA honors from Carleton University in criminology. And prior to practicing at MSB Barrister, she worked at a recognized law firm also in Ottawa. She was called to the bar in 2012. And today her practice focuses on complex criminal trials and appeals. She's conducted numerous homicide cases having to do with complex fraud, gun, drug, sexual assault, and impaired driving trials. And so she too regularly appears before all levels of courts in Ontario. And it's really a pleasure to have her with us today, and to serve as the first discussant. Our second, before she comes on, let me also introduce our second discussant, Omowumi Asubario Dada, who is a PhD student in criminology and socio-legal studies at the University of Toronto, where she's working on a dissertation project related to the complexities of choice and agency of female combatants who operate within Boko Haram insurgents in Nigeria. She is also a lawyer, in her case, a human rights lawyer with decades of experience working on issues related to social inequality, gender-based violence, women's participation, and legislative advocacy. She received her Bachelor of Laws from Lagos State University in Nigeria in 1999, and was called to the bar in 2000, having completed law school in Nigeria. She then went on to do a Master of Law degree with a specialization in human rights and democratization from the University of Pretoria in South Africa. And she has worked in law and public policy for close to the last 20 years, the past 19 years, where she's designed and managed projects related to women and legal reform. And she's contributed to significant projects connected to gender, and led national research surveys and done significant advocacy work. So both as a scholar and as an activist, she too will bring an interesting perspective as she reflects on the talk. So without further ado, then let's invite Anne-Marie to join us first, and then we'll just move straight into Wumi's presentation. Thank you.
Excellent. Thank you. So as indicated, I practice criminal law. I do quite a bit of trial work in mostly serious cases, which certainly impacts sort of my view in terms of attending court in person or participating in virtual or remote hearings. Certainly since the start of COVID-19 and the court's reliance on video technology, I have participated in a number of guilty pleas and sentencing hearings, various motions, an appeal, as well as many case management appearances. I haven't participated in a trial with witnesses and the cross-examination of witnesses by video, but certainly there's been much discussion with the defense bar over the appropriateness and the limits that should be placed on moving to virtual and digital hearings. And I can certainly indicate there's quite clearly a divide even within the defense bar about the appropriate cases and how we ought to be moving forward using digital and video court appearances, because it's quite clear they're here to stay. And so I do think a number of the points that have been raised today and in the paper are quite important in deciding and sort of determining how best we move forward to ensure that the court maintains both its legitimacy to the broader public, but certainly to the parties, the accused, the witnesses, the complainants, and the victims, and their family and friends. And I will indicate when we talk sort of practically, and I'd like to offer some more practical and sort of personal insights into how video courts have been conducted and the issues that arise within them. But certainly there needs to be a recognition that what a video hearing or a video court looks like, even within Ontario, differs greatly between the jurisdiction that you're in terms of the courthouse, the level of the court, but even sometimes within the actual courthouse, depending on the specific courtroom your matter is assigned to, the manner in which the technology is available, the manner in which it works, and what is actually visible on the screen during a virtual hearing differs quite significantly. And so depending on that, you see a number of different issues that arise, sometimes in certain cases that aren't in others. And I think for me, certainly as a defense lawyer, the starting point in criminal law is that there needs to be a recognition that criminal law and in the court process, it's a very important and a very significant event for those involved. Being charged with a crime has the potential to be life-changing and life-altering for that person and their family. Being the victim of a crime or even witnessing a crime also brings with it the possibility of being quite life-altering to those people and their family and friends. And so it's from that starting point that I think moving forward, the courts and the participants need to ensure that these individuals who participate in the hearing are also receiving a fair hearing and justice. As a defense lawyer, my focus is usually on the accused or my client, as opposed to sometimes more broader concerns. But certainly I view my job as not only to help my client in obtaining a favorable outcome, but to ensure my client not only receives a fair trial and a just result, but that he or she walks away from the proceeding feeling themselves that they received a fair trial and a just result. And built within that and ensuring that we give that to those accused people is our adversarial system, which is centered around having an independent, and impartial decision maker, which is again part of the constitutional rights that we have provided to accused people. And so where we see the image or the authority of the judge as that independent and impartial decision maker being altered or being eroded, I do think that there are constitutional implications with respect to the right to a fair trial, as well as ensuring the participants themselves feel that justice is being done. And so I want to start, I do have some comments, some of them sort of examples of where we see, based on the appearance of the proceedings, once we've removed them from the courthouse and the courtrooms, that certainly raise some of these concerns that have been discussed today. And again, I think they're related to the erosion or the lack of sort of personalization of a case, of the justice system, as well as how the court is able to personally engage with those in a particular case that are the involved parties, as opposed to the broader public. And for me, one of the features of not only the courthouse, but a courtroom, is that it is a place where justice is done, but where justice is open, at least in theory, to all. It is available for all. In theory, the courthouse and the courtroom provides an equal opportunity for people to avail themselves of the justice system. And it's the court, with the judge at the helm, that aims to treat all those who come before it with dignity and respect in an equal manner. And what that to me sort of symbolizes or focuses on is that whether you're rich, whether you're poor, whether you're on bail, or if you're in custody, if you're white, if you're Black, if you're Indigenous, that you can come to the same building, and literally the same building, the same room with the same judge, and receive access to justice. Whereas with digital and virtual hearings, this equalization or this equalizing effect of the courthouse is diminished, and it's diminished in particular to certain groups of people. And of course, the first would be the Indigenous accused or parties who simply don't have the ability to access digital proceedings. With the speed at which Ontario has attempted to move towards virtual and video conferencing hearings, there doesn't seem to have been a significant amount of thought put into what happens to those accused who are not able to access Zoom or video conferencing systems to participate in court. And we see it continually arising. I see it in my own clients who are either experiencing homelessness or don't have a smartphone. Their flip phone doesn't allow for the Zoom app. I also see it continuously in remote communities where the internet simply isn't strong enough, isn't reliable enough to be participating in court, and also just in more rural areas where, again, there are issues with the internet and the availability. And whether it's the internet cutting in and out such that the person isn't actually following the proceedings because they're not hearing them, the internet not working at all, or what tends to then happen, the response is that the accused who cannot connect to video is told that they can just call into a teleconference number and participate in that way, in which they would not be on the video. They would not see other people, and they're not seen. And what we then do at that point is we've taken at least one party, one member of the court proceeding, and we've put them into a different category. We've made them different. They're no longer equal. They're no longer on an equal playing field in which to participate in the hearing. And in my view, we're diminishing their role, their ability to engage in the proceeding, and making it less personalized, as the judge is not able to see that individual to have any sort of engagement or contact with. And related to that are the accused people who not just who don't have the technology, but those who aren't necessarily comfortable with the technology. And we sort of see that similar ways in which the focus of the hearing then becomes on whether they're following along, are they still connected? And they're focused on, well, am I doing everything right? Am I doing something wrong? And they're not then focused on what's happening or on what the judge himself or herself is doing. And of course, within these groups of people who don't necessarily have the same ability to connect, we see again that it's typically, and not always, but sort of typically the same groups of people who are already vulnerable and are already discriminated against in the criminal justice system, whether by the police in their charging practices or just generally once they come into the court system. And so I do think it's important moving forward that something is done, some consideration is done to how we return these vulnerable people to an equal playing field and to an equal standing in remote hearings. Additionally, setting aside those out of custody who don't have the ability, there are a number of concerns I continually see with in custody accused people being brought to virtual hearings. If they're brought, it's been my experience, to a video conference court appearance, they don't leave the institution, they don't leave the jail, which means they're often participating in court wearing their orange jumpsuit, their jail issued clothing. And at times they're sort of left in this small, tiny room without the full comfortable ability to participate in their own hearing. Whereas if they were brought to an in-person appearance or trial, they would be given the opportunity to change into not only their own clothes, but their clothes that would be appropriate for court, that would allow them to be comfortable and to participate with a level of dignity and respect. And it's the judge in those situations who is sort of in charge and has that authority to ensure in custody accused are being treated with dignity and respect and are able to appropriately participate in their own hearings. And they're not sort of left in this room to awkwardly stand there for 2 hours while everyone else just talks about them. And while these issues are sometimes addressed on an individual basis, case by case, depending on the lawyers and the judge, certainly it's something that as a broader issue going forward, we need to ensure that these people in these vulnerable groups who are in custody, who again, we know tend to be racialized, and that we're over incarcerating Indigenous accused as well as Black accused at staggering rates, that they're again brought into this equal playing field in which to access justice and in which to go before a judge and have that person truly be the person in charge and the person who, through their authority and the respect they command in the room, is in charge of the proceedings. And maybe just the last point on this that I'll add is in specific with respect to the judge, with the increase in virtual and video conferencing hearings, in my experience, the judge has become much more reliant on other people and other parties, such that it has the ability, certainly at least to appear, to be eroding their authoritative position in the hearing. The judge often no longer has the paperwork, it's all with the clerk. So the judge is reliant on the clerk or the Crown to get any information about the case, what's on the docket for that day, what's going on with the cases. And when all the technological issues arise, which they always do, the judge is never in a position to fix them or to send out instructions about what then happens. The judge is always reliant upon other people to come or to figure out the issue and to fix it. And some of that, of course, is just an issue with resources. But again, within custody people, we've reached a point in many jurisdictions in Ontario where the jails literally run the show. The jail will send out to the court the schedule for the day, indicating this is when you'll hear this matter, this is when you'll hear this matter, because those are the only times we will produce that accused person who's in our custody to appear before the court. And on many occasions, it leads to the jail either not bringing people to court or literally hanging up the phone or disconnecting the video when they want to move on to something else, despite the judge saying, we're not done here, this proceeding is going to continue. And the message that certainly sends is that it is not the judge who is in charge, and he or she is not the authoritative person in the proceeding. And I think that some of that certainly contributes to what I'm seeing at times as a diminishment of the fundamental role that the judge plays. And that role that they are is the sort of neutral, independent, and impartial decision maker who accused people and all parties should be able to look to ensure that they in fact receive justice. And I don't want to take too much more time so we can hear from everyone else, but I also just note that from my experience, it certainly is that in video courts, there has been an erosion of the formalities. There is a much more casual atmosphere. And it really is a struggle, and it's much harder to bring home that respect for the court process and the formal nature of the proceedings and the sort of solemnity of the proceedings over Zoom, where you have people based on what they're wearing, it's a more casual atmosphere. They're walking around the house, they're eating, they're drinking coffee, that they're checking their emails because you can see them, and they're doing all of these things that they would never think to do in court because there's nobody there to do anything about it. And of course, it means that any participant can certainly just disconnect or hang up whenever they want, and there's certainly nothing to be done about it. And certainly, my view, the comfort of being at home emboldens a number of people to act in that manner that they would never do otherwise. And a judge, by virtue of not being in the physical presence, really has a lot less control over the proceedings and over the parties. And so I think that maybe I'll leave it there so we can hear from other people. But certainly there are a lot of things going forward that need to be taken into account to ensure video court maintains an appropriate balance between the rights for all parties.
Terrific. Thank you, Ms. Morfu, for that engagement. And so next we have Wumi. So Ms. Asubiara Dada, thank you.
All right, thank you very much, Professor Clark, and thanks very much, Anne-Marie. Thank you very much, Dr. Akinroye, for that erudite presentation. I found your paper interesting when I read it, and listening to your presentation now, I must say that it is even more stimulating. I'm tempted to say fait accompli because the paper was clear and lucid, but permit me to raise 5 issues as discussion points for the paper. Firstly, I find it interesting that the preoccupation of your paper and the discourse around the online court processes is focused on what I would call the majesty of the law or court, and even more pointedly, authorial execution of justice. It almost suggests that justice that is not performatively seen to be done is injustice, even to the extent of injustice to both the offender and the judge, who by this online space is stripped of the opportunity of a charade of justice. Would you agree with me that depending on the context, what really matters is how factors such as institutionalization and court-dominated constitutionalism has defined the authorial majesty of the court? In the United States, for instance, the court is an institution and its authority is founded less in the claim of legal expertise than in hierarchical finality, the assertion of political will, not of legal judgment. The court has supplanted the Constitution as the authority in the US political world, and that is what makes legal sense. In fact, the whole court process is a celebration and maintenance of hierarchies that is suggestive of a high level of morality by a judge who sits on a higher pedestal in a hallowed hall of justice, looking down at the offender to hand over a sentence. Indeed, it would appear that the fate of the accused is then in the hands of the judge or even the lawyer, and not as determined by the law or the charter rights of the accused persons. Even when we argue that this fate is determined by the shared community values, this assumption begins to falter the moment we start to unpack the inadequacies apparent in the law, i.e., the so-called shared values, and how the hierarchies are established. Secondly, I'm wondering if instead we shouldn't be exploring the tensions between the perception of the victims of crime and the concerns that a virtual space vacates the court's authorial execution of justice. I recognize that there are varied categories of victims, but it would be useful to understand how victims of crimes such as murder or sexual assault would perceive the relevance of this authorial execution of justice that is sometimes adjudged to only be made possible by the court architecture. I would have argued that if indeed the court is the last hope of the common person, then it really should not matter it really should not matter that a process is stripped or devoid of its majestic garb. What should matter is that an appropriate sentence has been handed out and that the victim indeed feels that justice has been done. This said, it is worth considering what we gain by detailing questions concerning culture, authority, and power in the room. Why and how does it matter in ways that might help us appreciate the important considerations at play? Thirdly, what would it mean to also turn our attention to the victims of crime methodologically? Even though I share the concern that there's a temptation to romanticize the rights of victims to a degree that is unnecessary, but a consideration of how victims of crime would prefer justice to be performed is still essential. Are there differences in the accused? Are there differences for the accused in the sentences that are handed out during these Zoomed court processes in comparison with when the court held their sittings in person? What kind of methodology and data analysis would be involved in documenting the potential consequences in this technological shift? And how could an engagement that foregrounds victims' result in shifting the role that we consider video conferencing playing? If a victim-centered approach were used to shape the research design, how might your reading of the challenges and benefits of video conference change? The fourth point that I would like to note is concerned with the use of visual and digital technology that is live. What we see is that it was more established in criminal cases that involved sexual assault or what is referred to as vulnerable witnesses. Court had to establish a process of having the victim who serves as a witness in another location, but with a live broadcast used in situations where the judge has decided on evidence argued by the prosecution, excepting in rare jurisdictions where it is assumed that the presence of trial participants together in the same room may present impediments to a fair outcome. And I clearly agree with you, Dr. Akenroe, that due to increased caseload in criminal courts and the need to meet the presumptive ceilings for completion of trials, there is increased pressures in lower criminal courts to complete cases using a technology that requires heightened level of engagement. And this can be draining and tiring. Even course instructors within the academia are struggling with spending hours in front of a screen. Fifthly, and perhaps my last point before I yield the floor, is that I found your analysis of the performance of rituals interesting. I was amused by how the virtual nature of court processes vacates the rituals and demystifies court processes. This is akin to how technology, in the form of apps and various websites, is stripping exclusivity away from the legal profession. In some climes, you're able to generate a simple contract on a handheld device. And this form of exclusivity was described by Max Weber as how certain groups came together to establish a legal order that limits competition through formal monopolies. Some theorists have claimed that such exclusivity is a consequence of the class system, of elitism, or of a collective instinct for self-preservation. I would add to your brilliant analysis that the resultant effect of these acceptable civil modes of address is a profession that it considers itself as the only learned profession with knowledge for which huge fees are paid, and a semblance of an occult is established to keep more people out than in. It seems to me that we're on the brink of a period of fundamental and irreversible change in the way that the expertise of specialists is made available in society. Technology will be the main driver of this change. And in the long run, we will neither need nor want professionals to work in the way that they did in the 20th century and before. Related to this, I would like to invite you to throw more light on the substantive and technical judicial rituals beyond the example of the stare decisis which you have made in your paper. And it will be interesting to understand which other rituals are vacated that has grave implications for criminal proceedings and outcomes. Maybe this will throw more light to a poignant point that you made when you quoted Antoine Garapon's argument that while a relaxation of judicial formalism is supposed to favor the parties, it has the pernicious effect of increasing state control. Perhaps you could also clarify what is considered appropriate behaviors and if these are only expected of the accused persons. I find it interesting that you identify judges' inability to assess non-verbal cues as one of the disruptions to an assessment of credibility and reliability. How do we reconcile this with existing bias within the criminal justice system against BIPOC offenders? Wouldn't it serve the cause of justice better if we had blind court processes that can provide an assurance of procedural fairness? Ultimately, how is racial inequality a factor in the way that such dynamics are playing out in this period? And I'll just like to conclude, because there's so much more to say, but my time is limited, that this is certainly the start of an interesting conversation and theme that can be further explored to understand possible future developments that will have significant consequences for our world. For instance, for me, one of the possibilities that your paper raises is how technology can be an equalizer for reconfiguring power, which can be further interrogated using the lens of indigenous modes of dispensing justice. And I really would look forward to the engagement by the participants going forward. Thank you.
Great. Thank you, both of you. Wow, I think I'll give all of my papers to both of you from now on. Wow, so that was terrific. So Dr. Akinroye, there's significant questions and also some contestations here around your analysis, but quite generous in the engagement as well as appreciative. So can you just take maybe a few minutes, 5 minutes to reflect on the various comments and share with us your thoughts? Some of them, you know, we won't be able to deal with everything, but maybe some highlights. And then there are some interesting comments in the chat. I want to at least get an opportunity to raise some of them with you as well. Okay, thank you.
Okay. Thanks, Ms. Anne-Marie Murphy and Ms. Wumi Asundarodada for your excellent discussion of my paper and from flagging it in terms of practice, direct practice experience from Ms. Anne-Marie Murphy and also from an scholarly framework of analysis from Ms. Asundarodada. So in my presentation, I will just talk about them in broad strokes before we go to the chat, the comment in the chat, so that I can also entertain and engage those comments. In my presentation, I might sound as being traditionalist in terms of preserving the status quo. And like Ms. Murphy said, there is the divide, who divided the criminal bar, the first bar, in the utility or in the efficiency or the need for video conferencing or virtual remote hearing. Some feels that it's not good, some feels it's good, which is also replicated everywhere in the world, not just only in Canada. So this discussion is not coming from only Canada context, but everywhere in the world. But no matter the advantages, I'm not talking about that. There are several advantages. I can list them out there. Easy access to people to come to court. Lawyers do not need to stay in courtrooms for hours waiting for their matters to be called. Non-custody bail hearing can be done from outside of the court setting, and even the judges have a little bit of control or of control over their scheduling, just like Ms. Anne Murphy said, and Mary Murphy said, in terms of the prisons are telling them 1, 2, 3, 4, 5, this is where your schedules are going to be for today. But the problem that comes with that is the unpredictability of the internet connection because of the multiple parties that are getting involved in that process. We have the jail connecting people to the court. We have the court rely on reliability of the internet service for the judges themselves. We have it for the private bar people too. The defense counsel, things might happen. And then we have it for even the court staff. So there are too many moving parts that are not static, they're not predictable. So that throws up that unreliability on the way that the remote hearing doesn't function right. That's aspect of it. Beyond that, there's something that I want to mention, which is the fact where the person on the street says, I need my day in court. When someone says, I need my day in court, what does that mean? Is it a day in virtual court or a day in a physical location where he can say, I've been vindicated or I've been dealt with? So that is also an important aspect where we look at this aspect of remote hearing, the contestation around the image of the judge from the angle of when I'm in the courtroom. Which courtroom are we talking about? When I'm being accused of sexual assault, I need to be vindicated in the presence of my peers, and it doesn't come from the online environment. That's one aspect of it. The other aspect of it is when Ms. Ashimba Awoda that was talking about the issue of victims of justice. Who is justice meant for? The truth of the matter is justice is not only meant for victims of crime. Justice is meant for also the person that is being accused of a crime. Not only that, justice is also meant for the larger community that sees that the judge itself has dealt with their case, has upheld the community value. And that comes out in a remote hearing where the person that is being accused of a crime might not be able to participate effectively because of their socioeconomic background, or because they're experiencing homelessness, they are new to the country, they are new to the internet access, they are not able to obtain Wi-Fi, and therefore the justice being produced is not justice that is meaningful to them. But let's even interrogate it from the perspective of the victim of crime. The court system, the criminal law over the years have accommodated victims of crimes. That's why we allowed them to give their testimony, especially sexual assault, in a different room so that they and the defendant are not in the same space. Again, the victims of crime still sees, or they still find that justice is being dealt on their behalf in that other room, even if they are not there. But when we go to a remote environment, what do we find? We find a situation whereby victims are asking themselves, is it the kind of justice I want? Where the accused person is at home, feeling cool on his seat, on his chair, and just say, okay, just like the image I played to you. However, I will confess, it has not yet been totally interrogated in terms of empirical studies. And that's what part of my study is going to be at the University of Toronto, what victims think of the kind of justice by being dispensed by remote hearing. Let's move that aside. Let's go to the issue of the communication of values, where Ms. Wumi Asubiawo talked about, where you talk about the authority-based approach, where we need to disrupt this idea of authority. My own opinion, well, it's organized society. Authority is entrenched in our social fiber. That's why we have the police on the street exercising authority on behalf of the state, on behalf of the society. When we find ourselves in a space where there's no authority, or the institution of authority has been demystified, as we saw in the United States with Donald Trump and the people that went to Capitol Hill and went to the parliament and sat on Nancy Pelosi's seat. That shows that it has ripple effects on the society, and that is not what we want in that. So again, it's self-preservation. The rituals in court system is self-preservation. We preserve ourselves by wrapping up this kind of image of solemnity, of sacredness, of making sure that people understand that serious business has been done there. I'm looking at time. I still have a lot to talk about. I'm looking at that, but there's something I want to talk about the unintended consequence, to wrap up, unintended consequence of video hearing, especially for people that are from a racialized community or people that are marginalized, that are poor or vulnerable. Is when you do video hearing, you invite the judge inside your own home, and the judge can see what is transpiring behind you, whether your house is clean or dirty, whether you're a good father or a good mother or this, and can make inferences on those views that is beyond the scope of the case and make negative decision on that. Again, we will study. That's one aspect of it. The other aspect of it, when we talk about the racialized part of it, is where people that have means, that have money, can actually stage their background to influence the judge to issue a favorable decision. So there are pros and cons on it. My point, central point in this discussion on this presentation is that as we reimagine remote hearing in Canada, let's not go with the bandwagon of video hearing, remote is the best way to go. Let's say, how can we preserve our rituals, our existing process? Think of racialized group, people that don't have access to computer, to internet, and structure in such a way that the legitimacy of our judges and the authority are preserved and do not evaporate. I look forward to wider engagement with other people. Thanks so much to both discussants. I'm very grateful.
Oh, great. Thank you so much. So there are a number of really exciting comments in the chat. I wanted to just highlight, it's hard to even pick because all of the interventions are excellent, but let me just pick a couple initially and we'll see how we do with time. There's one from Audrey Macklin who says that you've established how genuinely alienating virtual hearings can be, but she, like Tyler King in his chat, is interested in hearing more about the impact of virtual hearings on credibility determinations. And I think, like King, Wumi also talked about credibility determinations as well, but through the lens of the category of the victim. Do you have any reflections on this point? And then I thought I would just quickly move to two other questions that came in the chat. Thank you.
Okay, so the issue, thanks Professor Clark for that question, and also thank you, Professor Audrey, for that good question. The issue of assessing credibility through video is a very hotly contested issue. Both scholars, different scholars, and the case law tend to say judges should not be given the authority or should not be allowed to base a decision on credibility finding based on what they can see, because judges are not expert at reading people, or it's not possible to read people if you don't have the expertise. Psychologists have written so much about it. The point at the end of the day is that your job as a judge is not to base your entire decision on credibility finding based on what I can see or that. For you to base your decision on credibility finding, at least there has to be facts before you, evidence disclosed before you that you're going to interrogate that will say, okay, I believe this, not because I'm seeing you crying or your face is hard, but there must be factual basis for it. However, having said that, in terms of the remote hearing part of it, especially audio, where someone is not familiar with it, someone might come on or off as being non-genuine, even when that person is genuine. And that's why a study conducted in the United States from in the city of Buffalo actually found that video conferencing or audio conferencing tunes out the frequency with human emotion. So someone that might be crying, you might not be able to identify that. And that poses a problem. But again, I've been taught, we have been trained that credibility finding cannot be made based on sight, but still, if it is distorted by the use of technology to an extent that you are not even sure of what you're hearing, or the image is not good enough, the angling of the light is not good enough, that you are not sure of what is going on, even with the factual basis, they might lead to unintended consequences. The point is, we need to be careful as we move to video hearing or use these technologies. And that's what my conclusion will be on that.
Okay, great. Thank you. So I'm just combining two comments, one from Anthony Igigbe and the other from Uchenna. And both of them are asking questions about truth claims. So in both cases, there are questions about, and especially in this moment where truth is under question in our social world, our media outlets, etc., different people watching different news channels, getting different kinds of reaffirmations of what they already think and what biases they already have. The point that Uchenna is making is that there's no real eye contact between the judge and the parties, and this has implications for witnesses. That often what we might see is witnesses reciting some script that is a constructed script that can be easily read versus the actual truth in which they're responding impromptu. We see the same from Anthony, the same question about these truth claims. Can you end with just some quick reflections on the implications by way of how we understand truth and how technology complicates that?
Those are good questions. And that is a reality that we found on the work, on the job, during the job, and also researching people who have done the job. The presentation of truth, it cannot be totally verified as coming from either the witness directly or the witness is being coached by a lawyer. Just like, let's imagine we are in a remote hearing right now. My phone is right before me. My lawyer can start sending messages to me and I can look at my phone and respond based on that. So what kind of truth is the court getting? And it makes the fact-finding mission of the court very difficult. There are ways people have proposed, when you want to start a hearing, turn the camera so that you can have a 360 view of your room so that there's no bother there with you. The camera in your phone is not there with you, something like that. But now that I've been on this presentation for the last 1 or 2 hours, several people could come into my office and do that. So the aspect of truth telling is being challenged by the move to remote hearing. And again, this is what this court designer needs to be conscious of. In the context of audio hearing, that's even worse because you cannot even see what is going on, whether the person is in the lawyer's office or whether the person has a lot of people beside him, other than you owe them to their word. Are you alone? Yes, I'm alone. Are you sure you promise to tell the truth? Is that the truth of the matter? And that is not the truth. Sometimes it could be the truth. So again, these questions are very important, that the truth telling is being imparted by video conferencing, in as much as we can be optimistic about it. That's the downside of it. And we really need to work on that aspect. That's why some lawyers, when I was discussing with Miss Anne-Marie Murphy, do not want trial by video hearing or video trial. And even the Ontario courts, at least the criminal court, are alive to that. And that's why most trials have been suspended for now, because of the version of truth that might be presented might not be the correct truth, or might be alternative facts that will impede or undercut or undermine the truth, the fact-finding work of our judges.
Okay, thank you. So we're a couple of minutes after the hour now, so we've pretty much run out of time. But there are more questions in the chat, some excellent ones that came in about Indigenous accused of in Canadian courts and sources of alienation, commenting on that, commenting on Indigenous approaches to justice and a number of other things. So there are many directions. You've offered us a rich paper with a lot of provocations for thinking about the fiction of justice in many regards and its implications. But we look forward to the paper progressing, and as the research continues, this is a difficult time in general around many of these questions, and this experiment is one of many that has significant implications, as well as implications for what the new norm will be. And in many ways, analysts, practitioners, scholars need to continue to stay vigilant. It's clear from the work that you've offered so far to stay vigilant about the consequences, and in particular around racialized people in situations in which access to justice is under threat. You've also offered us some theoretical language to think about judgecraft and authority and legitimacy, and the commentaries from our colleagues as well. So I think that there's a lot here, and we thank you for that. To wrap up then, just the next lecture in this series will be on Thursday, March 11th from 2 to 3:30, and this is with Michelle Goodwin, who's a professor at the University of California, Irvine, and she'll present her research from her book, Policing the Womb. So that's bound to be another excellent talk. So please join us for that. And if you can check out the center website, further information will be there for registering and signing up. So we've come to the end. Thank you, Kate McLeod, for your tech support. We have a few things by way of the translation to sort out in the future. And so thank you for helping us problem solve around that question. And thanks to the LSQ interpreters. It's a hard job. Some of it, we talk very quickly at times, especially when we've run out of time. So thanks for working with us in that regard. And of course, to all of you, to our presenter, Dr. Akinroye, as well as Ms. Morphew and Wumi. Thank you again for your participation, and thanks to participants for sharing with us your talks and reflections. All the best, everyone. Stay safe, and we hope to join you next time, March 11th, for our next talk in the series. Bye-bye now.